Good morning, ladies and gentlemen. It's a sunny day, isn't it? How are you today?
I'm fine, thank you, and you?
I'm tired. That's why I'm late. So today we're going to explore Chapter 4, the WTO dispute settlement system, which is what kind of rules? Yes, procedural rules, right? As usual, let's first recall what we've learned last week. Last week, we talked about the institutional rules of the WTO law. It's about the institutions and the decision-making of the WTO organization, right? So I've got several questions for you. Question number one. Which principle is at the heart of the WTO decision-making system and a fundamental democratic guarantee? Which principle? Think about it. At the heart of the WTO decision-making system. I'll pick someone to answer for us. Li Mingyuan. If you know it, say it. If you do not know it, say sorry. Okay. Then, Zhu Guanping.
Sorry.
So, last week we talked about the decision-making system of the WTO. Decision-making. What, who decides what, under what standards or criteria. For example, a simple majority, 2/3 majority, 3/4 majority. But what's the basic principle? I mean, prior to these choices, we've got which one? Exactly, consensus, right? That's the first step. So the consensus principle is the fundamental democratic guarantee and is at the heart of the WTO decision-making system. You have to remember that. The consensus principle. Okay, question number 2. Which method of decision-making is easier to be done? By consensus or by voting? Which one is more legitimate and democratic? Have you got the question clearly?
Yes.
Then, what's your answer?
I guess the voting.
Good, very good. The voting is much easier to be done, right? Then, which one is more legitimate? Wang Hao.
Pardon.
Okay, I'll repeat the question again. Just now, Yu Haoxiang said, voting, the method of voting is much easier to be done. While my second question is, which method is more legitimate, more democratic?
The consensus.
Good. Consensus, not consensus. The consensus principle is much more legitimate. Okay. Why? Because the opinions of almost every member are represented. That's why it's more legitimate. Okay. Question number 3. What's the principle of decision making by the DSB? What decisions by the DSB are taken by negative consensus? The first question is, what's the principle of decision making by the DSB? Similar to the standard procedure. It's also the consensus principle. Then, the more important question is the latter part. What decisions by the DSB are taken by negative consensus? Negative consensus. You still remember this? Negative consensus, which means only by one vote the decision will be made. Only by one vote the decision will be done. Under what circumstances? Maybe you cannot think of them so quickly. So I will tell you directly, okay? The answer is the decisions on the establishment of a panel, on the adoption of dispute settlement reports, or on the authorization of retaliation measures. This question we will talk about in this chapter in detail, okay? But the answer has already appeared in the PPT. Okay, next question. Next comes the difficult part. But I will say the question all the same. Question number 4, what fundamental provisions have to be accepted by all members before they can take effect? I will say it again. What fundamental provisions have to be accepted by all members before they can take effect? You know, for international agreements to be enforceable, we have 2 steps. Step 1, we let these agreements adopted by the WTO Ministerial Conference or General Security. Step 1, right? Step 2, these agreements will be brought back to the member states for ratification or acceptance. Is it correct? Good. Accept by the members. So my question is, what fundamental provisions need to be accepted by all members before they can take effect? All members, they must be fundamental, right? I will give you the answer. Listen carefully. Provisions concerning the MFN treatment obligation under the GATT 1994, the GATS and the TRIPS agreement, the GATT 1994 tariff schedules, and the WTO decision-making and amendment. These 3 fundamental provisions. Okay. Next question, question number 5. How is a decision to amend the DSU made? Is there a majority vote here? How is a decision to amend the DSU made? DSU. Today, we're going to talk about DSU, and that's the instrument I sent in the WeChat group, DSU. It's about dispute settlement understanding and about dispute settlement system in the WTO system. And my question is, if we want to amend the provisions of the DSU, we want to amend, change the provisions of DSU, what's the principle do we need to abide by? Is it a consensus principle or a voting? Good. It's a consensus. Very good. But there is another important question. How do the amendments to the DSU take effect for all the members? Also 2 steps, right? First step is by consensus, adopted. Step 2 is about accepted. Then my question is, how many members have to accept the DSU before the amendments to DSU take effect? Is it similar to this one? No. Do we really need these amendments to be accepted by all members? No. Good. Actually, we don't. We only need step 1. As long as these amendments are adopted by all the members, or by the General Council or Ministerial Conference. Which one? Good. Only by the Ministerial Conference. Then they will be adopted. Then they will take effect. Good. That's the most difficult part. Okay. The last question for last week is, in practice, are green room meetings harmful to the democracy of the WTO decision making? In practice, how do we make decisions? We use green room meetings, right? You still got the memory of that? We use green room meetings, and I've got an interesting saying is, how many steps are there? 3 steps, right? Yes. Okay, we will not go into the details of the 3 steps. My question is, in practice, are green room meetings harmful to the democracy of the WTO decision-making system? Yiden, what do you think? Do you think this kind of green room meetings harmful to the democracy of the WTO decision-making system? Yes or no? It's a very simple question.
Yes.
She's right. I second you. I agree with you. Why? Could you please give us some explanations or reasons for that? You can always use 1 sentence. What's the difference between these three-room meetings and the principle or the consensus principle. Okay, I'll let you go. Actually, I suggest to you, every one of you here, to grasp every opportunity to speak out, to speak up, okay? Most Chinese students learn English only by reading, and they are excellent at that. But the key to learn English well is to speak out. You know, there are 4 basic learning skills for English. First is reading, which most of the Chinese students are good at. The second is listening. I don't think for this part you're good at it. But we have one common word for this. They are all called input. Input. And the third part would be writing. Good. Writing. The fourth part would be speaking. Of course, we still have the fifth one. It's called translation, right? Translation. But these 2 parts together, we call it good output. If you want output, you have to get enough input, right? And that's why you need to read more, listen more. But this one, speaking, is more difficult than writing, because in writing you still got enough time to think, right? But when speak English, you have to react quickly, right? So you need to prepare in advance how to say something. Okay. And grasp every opportunity to speak up. Okay, good. Now let's come back to today's content. It's called the WTO dispute settlement system. Okay? Let's first have a browse of the table of contents. How many sections are there in your PPT, in your book? Maybe it's 8, right? I deleted the section 1 introduction part, so we make it now 7 sections. Have a browse of it. First is about the jurisdiction. Second is about the access to. Access to means use the system. And section 3 is the key features of the WTO dispute settlement. The fourth is about institutions, means the organizations, means the bodies of the WTO dispute settlement. And next one would be process of dispute settlement. We've got consultations, panel proceedings, appellate body proceedings, process. And the last 2 sections are about some minor issues. First one is about developing country members. We call it a development dimension, right? Development dimension. And the last one is about the challenges to the WTO dispute settlement. Today, we're going to finish the first 3 sections. I hope we can finish that. Let's hope we can do that, okay? but there are too many contents, we have to say. Okay. This part is the introduction part. Okay. I've got 2 questions for you about this page. What are the objects of WTO dispute settlements? And what does the WTO dispute settlement indicate? The objects. What does the objects of WTO dispute settlement mean here? A particular law or practice. So we are working around a particular law or practice of a particular member. Okay. Next question is, what does WTO dispute settlement indicate? The answer also lies in the PPT. The answer is indicates, means signifies. Means. What does the WTO dispute settlement mean or indicate? Where's the answer? Here, the last sentence. In WTO dispute settlement, might is not necessarily right. What does might mean? Might means power. Good. Power is not necessarily right. I'll give you an example. For example, the United States tends to adopt unilateral actions. Unilateral actions against other members. So, a lot of other members, I mean those weak ones, can go to the WTO dispute settlement system to sue or to file against the United States. The United States, if the United States lose the case, it will have to obey the rulings and recommendations adopted by the DSB. And that's why even a powerful country like the United States will have to bow in front of this WTO dispute settlement system. Okay. Next page. Because we don't have enough time for loads of contents, so we have to prioritize the contents and focus only on those key points. Okay. On this page, I have but only one question for you to think. For you to write. Question is, under GATT 1947, how shall the findings of the panel be adopted? Under GATT 1947. Under GATT 1947. How shall the findings of the panel be adopted? Good. Where did you find the answer? Where? Yeah, here, right? Shall be adopted by consensus of the GATT Council. At that time, do we have a DSB? At that time, in 1947, I mean, before the establishment of the WTO, is there something like a DSB? No. There's only a GATT Council. Only this organ or body. And the findings of the panels will have to be adopted by consensus of the GATT Council. Can you predict or guess what the results are? Do you think these kind of findings be able to be adopted? For example, I have one proposal for everybody here to make a vote. Do you think it's easy to be adopted? It depends. If I decided today's class, we will not have today's class. Everybody will raise up your hands, right? So it's very, very difficult because it's by consensus. Okay, good. Then what's the difference between this method and the method in WTO, DSM? You still remember here? In WTO DSM, the findings of the panels or the finals of the appellate body will be adopted by the DSB, or we say the General Council by which voting method? You still have any memory? We learned that in the general theory course. For example, there is a dispute and the panel has delivered its findings and there is an appeal and the appellate body has also given its own rulings. Then the rulings of the appellate body together with the findings of the panel will be referred to the DSB for voting. When voting, how do we adopt these instruments? We use the negative consensus method. What does this mean? What does negative consensus mean? Which means if there is only one member in the DSB vote in favor of the instruments, then all those instruments will be adopted. Is that easier? Yes, it's rather easy. And that's the charm of negative consensus. In GATT 1947, it's by consensus. It's only too difficult. And in WTO DSM, it's negative consensus. It's rather simple, right? Rather simple. Okay, we move on to next page. Section 1, jurisdiction of the WTO dispute settlement system. Three questions. For this page, we've got 3 questions. Listen carefully. Question number 1, what's the requirement for a WTO member to be subject to the jurisdiction of the WTO dispute settlement? What's the requirement for a member to be subject to the jurisdiction of it? What's the answer? What's the requirement for a WTO member to be subject to the jurisdiction of the WTO dispute settlement? The answer is here. Membership. As long as you are a member of the WTO, you are subject to the jurisdiction. You are able to be subject to the jurisdiction of the WTO dispute settlement system. Membership. Question number 2. What does exclusive mean? First, you need to find where is exclusive here. Exclusive. What does exclusive mean? Here. This is the answer. And what does contentious jurisdiction mean? Here. Are you familiar with this one? An advisory opinion. Where can you find this advisory opinion? Who can provide an advisory opinion? Good. What's the name of that organization? In English?
International Court.
2 words missing. The last 2 words. The last 2 words. ICJ. Sorry, I don't. International Court of Justice. ICJ. Right? Good. And this is a state-to-state judicial organ. State-to-state judicial organ. What about the WTO, DSM? Is it a state-to-state judicial organ? Or it's an investor state organ? This one. Of course, all the disputes in WTO happen between 2 members, right? So most of them are states. So we say WTO dispute settlement is also a state-to-state judicial system. Similar to ICJ. Got it? These 2, state-to-state. As opposed to in the international investment law, we got a different dispute settlement method. We call it what? ISDS. Still remember? Investor State Dispute Settlement. What did you learn in international investment law? Okay. Nothing? I didn't quite catch your words. Nothing? Let's forget it. Okay. Let's move on to next page. Scope of the jurisdiction. On this page, I still have several questions for you. Yeah. Question is, according to this paragraph, I'll give you a question. Is TPRM a covered agreement? First tell me, is TPRM a procedural instrument or a substantive instrument? Substantive agreements include only Annex 1. Annex 2 plus Annex 3, they are both procedural instruments. Okay? Then another question would be, is TPRM a covered agreement? All the substantive agreements, including the WTO agreement and all the substantive agreements, the DSO itself, and the plurilateral government procurement agreement, only one instrument missing, which is the TPRM. Where can you find the covered agreement? Where? Everybody, please open the DSU document I sent to you. Please, everybody. And go to the Appendix 1. I mean, the Annex 1. Can you find it? Can you find them? Open your documents and go to Annex 1. Let's find the covered agreements. Have you found? Where are you? Go to the DSU document and find Annex 1. The document go to the Annex 1 part. Annex, of course, in the end, right? In the end. Find. Try to find the covered agreements by yourselves. You're not there. Did you find them? Appendix 1. Appendix 1. Here, right? These are the covered agreements. Good. Can you find the TPRM there? Appendix 1. I'm sorry, this should not be Annex 1. It should be Appendix 1. Okay? You need to find all by yourselves. That's how to learn English. Oh, sorry, that's how to learn WTO law. Go to the instrument and find the covered agreements. Everybody, please do that. Go to find the covered agreements all by yourselves, okay? Have you found them? Have you found them? Good. Here, right? Is TPRM a covered agreement?
No.
No? Good. And is what you found there same with this part? Yes, right. Okay. You may imagine that all those instruments are too difficult, and I do not want to take it and open it and look for what you need all by yourselves. But actually, it's so easy. The answer is just lying there. Okay? Good. Let's take a 5 minutes break.